at some point, enough has to be enough, right? Even if you're the judge and you're in her pocket, I'm not saying you are, even if you are, even if she's influencing you in some way, even if you like her so much, even if you believe her, at some point, enough has to be enough. Because now we know Blake Lively and her team are claiming they fear for her safety and they don't believe that Brian Freeman and the Wayfair parties have good intentions with having her deposition at the location they've chosen because they think she's being set up to be harassed and intimidated. And oh my God, it's exhausting. I am literally, I'm tired. Physically, I am. Emotionally, I am. And if this is their strategy to just wear people down from talking about this, they might just be winning because I am exhausted from having to understand this woman's thought process. What do you mean you fear for your safety? Who has threatened you? Who at any point during this entire process, who has actually threatened you physically? Let's get into it. Oh, hello, everybody, and welcome back to another episode of F Around and Find Out. I'm your host, Elsie. I hope you all had yourselves a great weekend, productive weekend, a healthy one, a safe one. We have a lot to catch up on. I'm going to try to give you the highlights of the things that hit the docket, but I wanted to bring the focus on two things, maybe three, that really need to get across. And then the rest really are not that hard hitting, so they can just be highlights, like I said. First things first, Blake Lively and her team, we all know by now, wrote that motion to the judge suggesting that they fear for her safety. Not suggesting, actually, I take that back. They said straight up they fear for her safety and that the judge should do something about it because the Wayfair parties wanting to have their deposition at a certain location that we now know is redacted somehow doesn't work for them, and they want it to be done at a different location. And they go on to make these points of the fact that they've spent a lot of money to travel to said location, which if you do the math, Manat and whatever, the Phillips and Phillips law firm is in LA. And the point they keep making of we've gone to great lengths for travel expenses makes me believe they wanted to have the deposition in LA in their offices, which they do say, because they were going to have security and they were going to have refreshments. We're grown. We can all buy our own refreshments and lunch. And so I'm assuming they mean they've gone to great lengths to come to New York for the deposition. But we're going to get into that. Another thing we're going to touch on is you all have probably seen by now Perez Hilton's videos where he always makes mention to Brian Freeman being his attorney. And now that seems to be coming back to do a little bit of damage for the Wayfair parties because Blake and her team are using that as a sticking point to pretty much ask for more time for document production. So we're going to touch on that a little bit. But other than that, I'm just going to hit you with the highlights of some of the things that happened. And before I forget, there is a hearing, like I was telling you guys last weekend. No, not last weekend. Like I was telling you guys in the last video, there is a hearing scheduled for the 15th. We're gonna talk about it later. I'm gonna give you guys the phone number and the ID, the meeting ID, if you want to join. But please remember, you are not allowed to record that or stream it or anything like that. So if you plan to call in, please do, but make sure you do not try to record or stream or broadcast it in any way, shape, or form. Since we're already on the topic of the hearing, let's just start from there. And then later in the video, we're going to talk about Blake's letter to the judge about the fact that she doesn't feel safe to show up to depositions, which I feel like is just yet another way of trying to get out of that. Remember when Blake's team tried to ask the judge for more time, an extension for depositions? They wanted an extension on everything, right? And the Wayfair parties came back and they only agreed with extension for depositions to be extended till September 30th. So Blake's team writes to the judge saying, yeah, we saw your contemplated order, but that's not good enough for us. We're going to need more time. And one of the things they're standing on to ask for more time, I'm just going to shoot down really quickly. Specifically, they bring up the fact that they haven't been able to serve a couple of people their subpoenas, specifically Perez Hilton. If you've seen any of Perez Hilton's videos since this whole saga started, and I say saga because he says it so much now it's in my head, he's mentioned on multiple occasions that Brian Freeman is his lawyer. Blake's team is now using that against him. So, and it's actually in the footnote. So if you don't pay attention, you might completely miss it. Lively has drawn the distinction between notice subpoenas and serve subpoenas as she intends to imminently file motions for alternative service, at least as to Cynthia Barnes-Slater, Dervla McNeese, and Perez Hilton. So a notice subpoena is, say, I tell you, hey, expect a subpoena from me. I'm going to subpoena you, or you know it's coming. A serve subpoena is when you actually get it. So me telling you I will subpoena you, I might subpoena you, doesn't mean anything until I actually send you the subpoena and you get a copy and you sign for it and it's in your hand, right? So counsel for the Wayfarer parties do not represent these individuals and therefore have no authority to accept service on their behalf. I think they misspelled behalf there. That spells behaves. Okay. So the declaration for Kristen Bender, I'm going to show you guys later. She specifically mentions that the Wayfarer Party Council made similar representations that they did not represent a third party called Matthew Mitchell, going as far as to even require the court to rule on a motion for alternative service as to the third party. I don't really care about that part because they're going to make the point that they said they didn't represent this Mitchell guy, then they ended up representing him, which is a mess I'm not interested in. What I want to bring up is right here. It appears that Mr. Friedman currently represents at least Mr. Hilton, yet has not responded to requests for service to be accepted on his behalf. Perez Hilton made an Instagram video where he says, Blake Lively subpoenaed me, my response, and at minute 2:24 and 2:32, Perez says in that video, I have not been served with anything yet, and I also have not communicated with my lawyer, Brian Friedman.
But allegedly, Candace Owens and I have now been subpoenaed. Well, this is the first time I am hearing of it. This is not accurate. A more correct headline would be intending to subpoena. I have not been served with anything yet. And I also have not communicated with my lawyer, Brian Friedman, about this, who also represents Justin Baldoni and has not given me any information or influenced me in any way whatsoever. And I'm not going to hit him up about this because he'll charge me. And I'm not looking to pay over this conjecture at this point.
So the second link right there is Perez made another video where he says, I just scored a win in my legal battle against Blake Lively. Hilton taunting that he has not been served and will not be accounted for under the court's process schedule for July 25th, which he did go out of his way to say. We're going to play that video. If the court wishes the July 25th deadline for third-party production to apply only for served, not merely notice, because keep in mind, notices and served are completely different things. Subpoenas, Ms. Lively respectfully seeks that the court additionally require a deadline for production of 14 days. She's using this to literally ask for 2 more weeks to subpoena people.
Exclusively reported that the age of Ada-lying actress subpoenaed me. She still hasn't. Hello, my fam. It is Perez, the queen of all media, the original influencer, and your number one source for everything. It ends with us saga. This is about as close as Met Gala Medusa is going to get to me. It's been over a week. I'm out here living my best life, not avoiding a subpoena. I just haven't been served yet. And according to the judge moments ago, the clock is ticking. Quote, all document production by parties and non-parties shall be completed by July 25th. In parentheses, he says, third-party subpoenas shall require production no later than July 25th as well. Seeing as I still have not been served, the likelihood that they're going to get anything from me by July 25th is slim to none.
So right there in that video, Perez goes ahead again and brings up the fact that he still hasn't been subpoenaed. If they have to give up production by the 25th, there's no possible way you're going to subpoena him this late and expect your production by the 25th. Now Blake's team is using that point specifically to ask for more time from the judge. The problem with that is Blake's team is now telling the judge in this declaration that on July 10th, counsel for Ms. Lively emailed counsel for the Wayfair parties urging, please advise if you represent, will represent, or know who does or will represent any of the following: Cynthia Barnes-Slater, Dervla McNeese, or Perez Hilton, so that we can save the court unnecessary motions for alternative service. They say the same day, the same evening, counsel for the Wayfair parties at Linear Friedman responded with Mr. Friedman copied, we do not represent these individuals and therefore have no authority to accept service on their behalves. The problem with that is because Perez has made all these videos saying Brian is his lawyer now, Brian Friedman probably was his lawyer in a previous litigation. He's probably served as his lawyer before, but that does not mean he's his lawyer moving forward. He doesn't have him on retainer. Unless he has him on retainer, he's not his lawyer. The correct term or the right way to say that is Brian Friedman has been my lawyer before, or I've used him as a lawyer before, because now they're using that as a point to talk to the judge and be like, well, Brian Friedman told us in the past somebody wasn't his client, and the person ended up being his client. So if he's saying Perez is not his client now, he could end up being his client. So we need 2 more weeks. Like, they're using that as a point, and they're probably going to get away with it because there's so many times he's mentioned that. Considering how messy and confusing it is all becoming, the judge has just gone ahead and scheduled a hearing for Tuesday, the 15th. So the court will hold a hearing on the scheduling of discovery in this case on July 15th at 3:30 p.m. Counsel will participate by Microsoft Teams video conference with dial-in information provided by email. The public or press may access the hearing by dialing 646-453-4442 and using conference ID number 358639322. Please keep in mind you're not allowed to record the calls. You're not allowed to stream it or anything of the sort. Please remember that. All right. So we can start with this. Blake's team filed a motion to seal. They want to seal the location for her deposition and also a protective order on what happens at the deposition. They also want a list of everybody who will be at the deposition. Keep in mind, everybody, from all the parties are allowed to show up to the deposition. So anybody from Jen Abel to Justin Baldoni to Melissa Nathan, anybody can show up to depositions if they want, between the lawyers and the people in the case. Even though Blake's team is requesting they need to know who's going to be there before they show up, the Wayfair parties don't have to do that. They could just show up and be like, well, we're here. And your security measures can happen that day. We don't need to give you a list ahead of time. Like, you're not going to say if Justin wants to show up to the position, you cannot say you won't let him in on the day of, which I don't think he has the time to even show up. But if he wanted to, it's his right. So Blake's team filed this to the judge saying they want a motion to seal everything, including the location of the deposition, which is scheduled to be held on the 17th. The court has previously recognized the uniquely public and media-driven nature in this case. This is a case as to which there has been a lot of public attention. The details of this case have been closely followed in the media, in addition to the traditional media, social media personalities, and internet sleuths pour over the details of every public filing. Under such circumstances, the public revelation of the final location of Ms. Lively's deposition invites not only a media frenzy upon her arrival or departure and otherwise, but also threatens to endanger Ms. Lively's physical safety. Really? Notwithstanding anticipated security measures. Her physical safety? Okay. Any legitimate interest the public may have to the precise location and time for Ms. Lively's deposition is extremely limited. We don't care. Nobody cares. We just want her to show up and answer the questions. To the contrary, there is a strong interest in ensuring that Ms. Lively's physical safety is protected. My eye is literally twitching because nobody cares about that lady like that. Under the circumstances, any limited legitimate interest the public may have in this discovery document is heavily outweighed by the countervailing interest in protecting Ms. Lively's physical safety. Anytime you hear physical safety, take a shot, okay? In addition, the proposed redactions are narrowly tailored to serve this purpose, consistent with the presumption in favor of public access to judicial documents. Blake really thinks we give that much of a shit about her. That's crazy. So for now, document 413 and 414 are not available to read, but this one is a doozy. Plaintiff Blake Lively respectfully moves the court to enter a protective order directing defendants to conduct Ms. Lively's deposition, currently scheduled for next Thursday, July 17, at redacted, and disclose the identities of all individuals who will appear. Like I was telling you, anybody can come, but they want to know ahead of time, right? Ms. Lively regrets the need to burden the court. So why are you doing it? The need to burden the court with this request, and does so only after defendants have refused Ms. Lively's reasonable request and instead insisted that Ms. Lively's deposition take place at blank. Keep in mind, whoever's conducting the deposition gets to choose the location. Just because you're Ms. Lively, you don't get to say like, oh no, if Brian Freeman and the Wayfair parties want to hold depositions at the fucking Chuck E. Cheese, you show up at the goddamn Chuck E. Cheese and you show up on time. You want to hold the deposition in Botswana, you get on a plane and you go to Botswana. You don't get to be like, yeah, no, I want it here, I want it there. Defendants have not denied that their intent is to manufacture a harassing publicity stunt by requiring Ms. Lively to parade through paparazzi or by inviting unknown attendees to the deposition, including members of the media or social media influencers or any other members of abusive tactics. I can't. Do we have to keep doing this? I'm only doing this because I feel like you guys would not find this out if we don't read this to you or we don't tell you about it, because this is what she really thinks in her head, that the Wayfair parties are going to hire people to come and harass her, which only makes me think that's what your team is going to do. Your team is probably going to find people to pay to harass you just so they can say the Wayfair parties did that. I won't put anything past you. Despite Ms. Lively's repeated efforts to confer, defendants have refused to address these concerns and have responded only with their insistence that they alone control all logistics and security issues. It's their deposition. They get to do whatever they want with it. Defendants' failure to acknowledge the real security and privacy risk ignores that they have engaged in retaliatory, here we go again, harassment that has extended into the litigation itself, including by defense counsel's repeated and personal attempts to turn Ms. Lively's deposition into a media event. Since virtually the inception of this litigation, defendants have used even the prospect of Ms. Lively's depositions to generate press interest. Defense counsel publicly demanded the earliest possible deposition of Ms. Lively in advance of the first court hearing on January 30th, resulting in a predictable wave of sensationalized press coverage. On May 8th, 2025, Mr. Friedman made unprofessional comments to People magazine about Ms. Lively's deposition, preposterously declaring that he wanted to hold it at MSG, Madison Square Garden, sell tickets, or stream it. It was funny. Laugh it off and get over yourselves. And that if Ms. Lively is willing to sit for a deposition, I am available. How does tomorrow morning work for her? It was meant to be funny, Kristen. Get over yourself. Just days after defendants noticed Ms. Lively's deposition, Mr. Friedman sat for a lengthy conversation interview with TMZ in which he announced, I've noticed her deposition. It's set in June. We're going to see if she's going to appear at that deposition or not. Spoiler alert, she didn't appear. During a conferral on June 13th, defense counsel insisted that Ms. Lively's deposition must be the first deposition taken. Ms. Lively agreed and offered July 17th, which defendants accepted. On July 7th, Ms. Lively's counsel emailed to confirm the plan for the upcoming deposition consistent with the practice adopted by the parties for the deposition scheduled to date. Separate and private breakout spaces will be provided for attending parties and counsel, as well as lunch and refreshments. We are also happy to coordinate logistics and blank with a court reporter and videographer if you would like. For security reasons, we'll require a list of all persons who wish to attend the deposition by no later than Friday, July 11th. Opposing counsel responded by insisting without any articulate reason, which they don't have to give you. They don't have to give you any reason other than we don't want to do what you want to do. You have provided no reason for refusing. Again, they don't have to provide. This is exhausting. I'm not going to keep. It's like whining. You have not agreed to a reasonable request. It's not. Breathe, girl, breathe. Okay. We're just going to jump. Opposing counsel responded virtually, immediately writing that we expect to see Miss Lively at 9 a.m., which I love. I'm going to show you guys that email. That was from Ellen Garofalo, Queen, okay? Defendants have not attempted to demonstrate that the cost, convenience, or litigation efficiency warrants holding the depositions at blank rather than at blank. Oh my God. Did she have professional assessments when she was holding her Betty Boo's events? Did she have professional assessments when she and her husband were pretending to walk down the pavement, pretending to walk down the road with their stroller and their baby? Defendants do not appear to have considered such scrutiny. Again, I'm so sorry, guys. If you want to read it on your own, you're going to have to find it and do it. I can't do it anymore. It's going to be document 415 on a docket. I'm moving on because I'm exhausted by it. Like, these cannot be grown people whining like this. What I am going to show you is the email from Ellen Garofalo, which pretty much told Kristen Bender where she could go bend and shove it. By all accounts, if you ask me, Blake's team is trying to find a way to push the positions. They just want Brian Friedman and his team to do it. They want it to seem like the depositions were moved because Justin's team wasn't ready, not because they don't want to. Because Kristen Bender sent this email to Ellen Garofalo, which Ellen responded with, so chef's kiss. It wasn't as animated as go bend and shove it somewhere, but we'll get to it. So Kristen Bender sends this email to Ellen. Ellen, if you believe it makes sense to continue the deposition until all discovery is complete, then you should do so. You seem to want to weigh in on your decision, but we have no obligation to make that assessment for you. You decided that Ms. Lively must be the first deponent, and you selected this date. And if you decide to move forward, that too will be your choice, and you will be held accountable for your own strategic decisions. Why do you care? Why do you even sound like you're giving me advice? If you're a good lawyer, you know your client is clear, you know your client is ready to go. If I'm making a strategic mistake, you should shut up and let me do that. Why do you almost sound like you're giving me advice to steer me in another direction? Let me make my mistake and take advantage of it. Except you're afraid. You're trying to literally get me to blink. In the event you later decide that it would have been advisable to have scheduled Ms. Lively's deposition later in the discovery period, Ms. Lively would not sit for a deposition for a second time based on your strategic miscalculations. This is your deposition, and you have both the right and the obligation to conduct it in a manner that you understand will be consistent with the court's instructions that no witness in this case will be deposed more than once. Given the limited time left before July 17th, we have respectfully urged you to discontinue all posturing and gamesmanship around the scheduling of the deposition so that we can address the needs of not just our client, but numerous attorneys whose schedules are in limbo as a result of your numerous requests that we reach a mutual agreement to postpone Ms. Lively's deposition. Just continuing, because your email below states that you will proceed with Ms. Lively's deposition on July 17th, notwithstanding your reservations and your clear preference to move it. How are you going to tell me what I want to do? You have not agreed to our reasonable request to hold the depositions at, I'm pretty sure, our LA offices. That's the only thing that makes sense. Nor can only assume that it is because you intend to make a media show of Ms. Lively's deposition in some way, both inside and outside the court, both inside and outside of the deposition room. If we don't hear otherwise from you by 12 p.m. tomorrow, we will promptly file a motion for a protective order at the time in which we will ask for the court to order these clearly warranted parameters for the deposition. Likewise, if you later move the deposition, we will seek sanctions against you, blah, 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 blah. Kristen Bender, you know where you could go bend and shove it. You and all your clients cause blah, 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 blah. We continue to not understand blah, 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 blah. Ellen Garofalo, being the queen that she is. Talk about posturing. In any event, we expect to see Ms. Lively at 9 a.m. on July 17th at blank for her deposition. Sent from iPhone. She didn't even leave with a have a good day, have a good night. Sent from iPhone. Somebody left me a funny comment and was like, the funny thing is if we see Ellen Garofalo with an Android. That would mean she literally typed send from iPhone. She couldn't even bother to send that from a laptop. Like, she read your email and was like, oh girl, you are so boring. sent from my phone. That's going to be it for today. I can't wait for the hearing on Tuesday, tomorrow, and what the judge is going to say or rule in reference to the extensions, and possibly what he's going to say about this protective order and Blake wanting to switch, deposition location and give us a letter and a notice of who's coming and blah, 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 which you don't get to do that. Like, the deponent does not get to pick all of that. But I digress. I appreciate you guys for being here. Thank you so much for 20K once again. Please make sure to like, share, subscribe, leave a comment, and have yourselves a great day. Bye-bye.